Today's video is part 2 of a 2-part series going over HIPAA, the Health Insurance Portability and Accountability Act of 1996 as amended. My name's Gregory Singleton. I'm an estate planning and probate attorney who lives in Minneapolis, Minnesota. I work for Signature Law, which is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just as a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. Also, 2 caveats before we get going. First of all, these videos are for educational purposes only. I am not giving legal advice. And secondly, we're going to be talking about Minnesota law anytime we touch on state law. Now, HIPAA is a federal law, but we're going to be taking a Minnesota view at it. In part 1, we looked at what is HIPAA, what are some of the rules that govern the structure of HIPAA and establish what rights and what obligations and who's covered under HIPAA. In today's video, we're going to look at first the civil penalties, then the criminal penalties for violating HIPAA, and then we're going to look at what is the importance of HIPAA to estate planning. Why are we even talking about it here? With that, let's just jump right into the civil penalties here. There are, if you violate HIPAA, there's a civil penalty, and a civil penalty means it's a monetary penalty. You have to pay money, pay fines. It's based on culpability. There are 4 tiers of penalty, tier 1 being the least culpable, tier 4 being the most culpable. Tier 1 is doing a violation of HIPAA with maybe a lack of knowledge of what's going on. Tier 4 is having a violation of HIPAA based on your willful neglect and then not correcting it for 30 days. Tier 2 and 3 are somewhere in between. Now, each tier of penalty has a minimum penalty, a maximum penalty, and then there's an aggregate penalty per year that you can be fined. For instance, minimum penalty for a tier 1 violation is going to be $127, but minimum penalty for a tier 4 violation is going to be $60,973. That's a big difference, and it's a big difference in what happened. Maximum penalty for a tier 1, actually tier 1 through 3, is going to be $60,973. And a maximum penalty for a tier 4 violation is going to be $1,919,173. Now, all tiers have the same max penalty per year, which is just, again, $1.9 million and change. I'll also say that if you get hit with a civil penalty for HIPAA, you will immediately be hit with a corrective action plan or forced to come up with one, a plan that addresses the underlying issues leading to the HIPAA violation. Criminal penalty. Remember the difference between civil law and criminal law is civil law, you just pay money. Criminal law, you go to jail, possibly pay restitution. Criminal penalties for HIPAA are for a violation where an individual knowingly obtains or uses PHI for non-permitted reasons. Again, we have tier 1 through 3. Tier 1 is there was reasonable cause for doing what they did, or there was no knowledge of the violation. That can lead up to a penalty from 1 year in prison. Tier 2 is obtaining PHI under false pretenses. This is a penalty up to 5 years in prison. And Tier 3 is obtaining PHI for personal gain with malicious intent, which could be up to 10 years in prison. So if you're pretending to be a doctor and stealing PHI, tier 2. If you intend to blackmail the individual with that PHI, it's probably going to be tier 3. By the way, you're probably also going to lose your license to practice law or any right to practice law that you have. So simple advice, don't violate HIPAA. The final part that we want to talk about today is what is the importance of HIPAA to estate planning. Key concept here is a HIPAA waiver. HIPAA waiver is a document that authorizes a covered entity to give out personal or protected health information, PHI, to a specific individual without violating HIPAA. So it's a get out of jail free card in a way. We've got 5 core documents to estate planning: the Healthcare Directive, Durable Power of Attorney, Guardianship Directive, Revocable Living Trust, and Will. Let's walk through each of those and see how HIPAA plays into enforcement of the document. The first one is the Healthcare Directive, and this one's a little bit foggy, but the story goes, in ye olden day, at the outset of HIPAA, someone could be appointed under Healthcare Directive to be a healthcare agent of someone The principal, the individual that it's their healthcare directive, could be in a car accident, go into a coma, be on a ventilator. And then the agent comes to the hospital and goes to the doctor and says, "Doctor, I am the healthcare agent. I need to know what's going on so I can make decisions." And in ye olden day, doctor could turn to individual and say, or to the agent and say, "I'm sorry, telling you what's going on with my patient is a violation of HIPAA and I can't do it. So you're authorized to make decisions. I just can't tell you what's going on." And that is a pretty bad situation to be in. Now, Minnesota saw this and corrected it pretty quickly. They passed Minnesota Statute 145C.08 that states that a healthcare agent has the same rights as the principal to receive, review, and obtain copies of medical records and to consent to their disclosure. So in Minnesota, you can be a healthcare agent and not have a HIPAA waiver. However, what if you're in a state that has not enacted a similar statute? What if you're in a state you're traveling and you're traveling across the state? You get in a car accident, you go into a coma, your healthcare agent comes there. In Minnesota, you would have been fine, but now you're traveling in Timbuktu, and the healthcare directive is no good unless you have a health care or HIPAA waiver. That's a problem. So it's one document. It's easy to execute. You might as well do it just in case. My job as an attorney is to be a bit paranoid and look at all the things that could happen. And this is one of those times that paranoia takes over. The next document we look at is the durable power of attorney. In fact, I'm going to look at the durable power of attorney, revocable living trust, and guardianship directive at the same time. Each of these may or must have a springing component. A springing financial durable power of attorney is a financial durable power of attorney where the attorney in fact does not have authority to act until a certain event. Often that certain event is incapacity. Revocable living trust, a successor trustee will take over when the settler trustee is incapacitated, and a guardianship directive, the guardian will take over for the parenting responsibilities of the children when the principal is incapacitated. The question is, how do we determine incapacity? You write this into the document, honestly. You can write whatever you want. But some people say, if my trustee determines that I'm incapacitated, then I'm incapacitated. Or if my spouse determines it. But more often, I see one of two things. One is you're incapacitated if a court appoints a custodian or a guardian. Basically, they're saying someone needs to take over your financial affairs because you can't do it yourself. You're incapacitated. Or for guardian, must take over your health decisions and your decisions about your body. In that case, it's law of the land. You are incapacitated, therefore it takes over. But the most common way of determining incapacity is having a doctor examine the principal, determine that they do not have the ability to make financial or health care or parenting decisions for themselves. Therefore, the durable power of attorney, the successor trustee, or the guardianship directive needs to take over. In that case, you're getting a doctor to opine in a letter saying this individual is incapacitated. This individual has a medical condition. That's protected health care information. So, in order for the doctor to release that PHI, we need to have a health care or a HIPAA waiver authorizing them to write that letter. And that's pretty important. Otherwise, the durable power of attorney doesn't go into effect. The successor trustee cannot take over, and the guardian cannot oversee and parent the children during incapacity. So, for those three documents, it is absolutely vital to have a HIPAA waiver. The fifth document is the will. Minnesota allows PHI by statute to be released to a personal representative or to a surviving spouse. I have not yet found a reason why we need a HIPAA waiver for a will. So I don't think there is one. So don't worry about it. But the other four documents, healthcare directive, durable power of attorney, guardianship directive, and revocable living trust, all should have a HIPAA waiver active, allowing a doctor to do what they need to do. Okay, so that is part 2 of our exploration of HIPAA, the Health Insurance Portability and Accountability Act of 1996. I hope you liked today's video. If you did like today's video, please feel free to hit that like and subscribe button. We do a new video every other Wednesday. So you have that to look forward to. If you have questions, leave them in the comments below or just send me an email. My email will pop up at the end of the video. Otherwise, until next time, this is Gregory Singleton from Signature Law.